Hello, future travelers. Welcome back to Legalopolis. Friends, if you are an H4, adjustment of status, or any other EAD holder, listen up. There's a major change you need to know about. The Department of Homeland Security has just announced an interim final rule that ends the automatic extension of employment authorization documents, that is, EADs, for most categories. But don't worry, we are going to break it down step by step so you'll know exactly what this means for you and how to stay prepared. To understand this new rule, let's take a quick look at how we got here. Back in 2016, USCIS introduced a 180-day automatic extension for EAD renewals. In 2022, this was temporarily increased to 540 days to help prevent job gaps caused by processing backlogs. Then in 2024, the 540-day extension was made permanent for certain categories. Now, in 2025, DHS has decided to eliminate the automatic extension entirely for most applicants. And that's why on 29th of October 2025, DHS officially announced this interim final rule which takes effect for renewal applications filed on or after 30th of October 2025. Now here's what's changing. Previously, if you filed your EAD renewal on time, you could continue working while your renewal was being processed, sometimes for up to 540 days. But starting October 30th, 2025, this automatic extension ends for most EAD categories. DHS says the rule is designed to strengthen security checks, prevent fraud, and ensure public safety by making sure work authorization is only granted after proper vetting. This means that from now on, if you file for renewal, your work authorization will expire the day after your current EAD expires, unless you have another independent basis to work such as an E or an L status. You'll then need to wait until USCIS approves and issues your new EAD card before you can legally work again, which could definitely result in a gap in employment. Now let's see who this new rule applies to. This new rule applies to most EAD categories, starting with adjustment of status applicants, also known as CO9, who are waiting for their green cards and rely on work authorization while their applications are being processed. Next are H4 dependent spouses, that is, the spouses of H1B visa holders who have been eligible to work with an EAD. Then comes refugees and asylees, and also applicants for asylum or withholding of removal who have pending applications. VAWA self-petitioners, including their qualified children, are included in this category as well. Finally, temporary protected status EADs are affected, although some TPS EADs may still benefit from special automatic extensions if provided by law or announced in the Federal Register. So while most categories are included, it's important to double check your specific situation to see if any exceptions. Okay. Now, let's look who is not affected by this new rule. Firstly, spouses of L and E non-immigrant visas are exempt from this rule because their work authorization continues incident to status. This means they can keep working even if their EAD card expires as long as their underlying E or L status improve, and they can use their valid I-94 to prove continued work authorization. Next, F1 students on OPT or STEM OPT are completely unaffected. Regular OPT has never included an automatic EAD extension, and STEM OPT students will receive a 180-day automatic work authorization if they file a timely Form I-765 while their current EAD is valid. Finally, other legal extensions that are mandated by law or announced in the Federal Register such as certain TPS extensions, may still apply. So while the new rule affects these exceptions ensure that some individuals can continue working without interruption. Now let's talk about what you and your employer can do to stay compliant and avoid a gap in work authorization. Firstly, file early. If your EAD category is affected, the best way to protect your ability to work continuously is to submit your renewal as early as possible. USCIS recommends filing up to 180 days before your current EAD expires because waiting too long could result in a job ending gap while your renewal is pending. Secondly, employers need to update the I-9 compliance immediately. A Form I-797C receipt notice for a renewal filed on or after October 30th, 2025 will no longer serve as proof of continued work authorization once the current EAD expires. This means the employees must be removed from active payroll unless they have another valid basis to high volume. Finally, plan for possible gaps. Because USCIS processing times sometimes can exceed beyond 6 months due to high volume of applications, and therefore it's wise to coordinate with your employer as to how you will manage any potential gaps in employment. So friends, I hope this video has brought about some clarity for you regarding this significant rule change as regards EAD. While the end of automatic extension introduces a challenge, remember that filing early is your best defense against a work gap. Stay proactive, stay informed, and keep open communication with your employer to avoid any disruption. Friends, if you found this video helpful, please consider subscribing. It truly means a lot to us. Wishing you smooth processing and steady progress in your journey. And until next time, safe travel!